Welcome to today's Federalist Society virtual event. This afternoon, Tuesday, March 7th, we will be discussing lawyer shaming, legal ethics, the rule of law, and access to justice. I'm Melita Cass, Vice President for Strategic Initiatives at the Federalist Society and Director of the Freedom of Thought Project, an initiative addressing new challenges and questions involving freedoms of thought, conscience, and expression. Today's program addresses the growing problem of lawyer shaming as a source of explicit, implicit, and systemic bias that threatens equal access to justice and the rule of law. We are seeking 60 minutes of ethics credit for today's program, specifically in the areas of diversity, inclusion, elimination of bias, and similar anti-bias categories for all states that have adopted such requirements. Please see the CLE accreditation chart on our registration page for updates on approved credit hours by state. We will post a chat in the chat box at some point during the presentation, a CLE code. A notification will appear on the screen to alert you that the CLE code has been posted in the chat box. Please write the code down as you will need it to provide it when you complete your certification of attendance. I'd now like to introduce our speakers. Their complete bios are posted with the other CLE materials on the registration page, so very briefly, Stephanie Holmes is the founder of Brighter Side HR, which covers HR training and consulting with what she calls a refreshing approach to diversity and inclusion. She started her career working in labor and employment law in private practice and in-house. She also studied mediation at Northwestern University and has years of experience resolving workplace conflict. John Urich is the Associate Chief Counsel at the U.S. Chamber of Commerce Litigation Center. John rejoined the Chamber recently after helping launch the litigation boutique Lahotsky Keller. He also speaks frequently on the lawyer shaming phenomenon and on how the erosion of professional norms in the legal culture might threaten the rule of law. As always, please note that all expressions of opinion offered today are those of the experts on today's program. After our speakers have covered the essential items on the agenda, they will turn to submitted questions. So please submit your questions through the Q&A feature at the bottom of your screen. With that, thank you for being with us today. Stephanie and John, the floor is yours.
Well, thank you to the Federalist Society for having this conversation today. And Jonathan, it's a pleasure to be here with you this afternoon. So lawyer shaming is what we're here to talk about today. Up until recently, there seems to have been widespread agreement that lawyers should not be shamed and should not be punished for representing unpopular clients or even the most despicable clients. So Jonathan, is that right? And if so, how far does that, kind of traditional norm date?
Well, thanks, Stephanie. And it's also a pleasure to be here with you today. And huge thanks to the Federalist Society and the Freedom of Thought Project for putting on this great CLE program. I'm really excited to be here. Just want to get a quick personal disclaimer out of the way. As you all know, I'm a lawyer for the U.S. Chamber of Commerce's Litigation Center, but I'm here today doing this course in purely my personal capacity, so my remarks here today do not necessarily reflect the views of the Chamber's Litigation Center or the Chamber as a whole. But with that sort of out of the way, and to answer your great question, I think the answer is yes, actually. Throughout American history up until fairly recently, I think there's been pretty widespread consensus in our society, both within and outside the legal profession, that lawyers shouldn't be shamed or punished or criticized for representing unpopular clients. And that is, of course, a norm of legal professionalism, but it's also a broader value, rule of law value of American society. And that value, I think, dates back at least as far as John Adams's famous 1770 representation of the British redcoats who were accused of murdering American patriots at the Boston Massacre, which an incident that I think we're all familiar with as lawyers. And what's fascinating about that is at the time of John Adams's representation, his private practice actually suffered because of his quite unpopular representation of those British redcoats. But of course, it didn't harm his political career over the long run. He went on to be the second president of the United States. And actually, this representation by John Adams actually came to be regarded as one of his finest hours. And so it came to be regarded as sort of a paradigmatic example of the noble role and essential role that lawyers play in ensuring that even the most unpopular and despised among us receive the benefits of the rule of law through effective legal counsel. And that's become a model for lawyers to this very day. And so in accordance with that example set by John Adams that we revere, American lawyers have a long and celebrated tradition of representing pretty unpopular and despicable clients, whether it's from defending accused Axis war criminals after World War II to, free speech litigation representing, disfavored and controversial speakers with extremely odious and offensive views that I think we would all abhor, but that nevertheless that litigation was essential in establishing landmark free speech precedents. And of course, every single day in our country, criminal defense attorneys and public defenders represent defendants accused of committing heinous crimes, all the time. And we regard all of these representations, as fundamentally important and noble, a noble role of lawyers in our system. But all that said, and despite this history and this very strong norm, we have had occasional episodes in our history where our society forgets the norm and it breaks down somewhat. In the 20th century, just to take two examples, we had, lawyers that represented suspected communists or who themselves may have been suspected communists were shamed for those representations. And similarly, during the same rough period, civil rights era lawyers pursuing civil rights on behalf of black clients were shamed and targeted and criticized for that representation. But the key is, as an American society and as a legal profession, we look back on these episodes with shame and we recognize them as fundamental violations of this core norm of our profession and of our society. And so we've recommitted ourselves to that norm. And as we'll be discussing today in the course, when that norm is discarded and lawyer shaming occurs, it harms not just the lawyers that are targeted by the shaming and the criticism, but the entire legal system. It's inconsistent lawyer shaming with the fundamental principles of legal ethics. It impedes access to justice, especially for minority and disadvantaged clients. And as a result, it ultimately undermines the rule of law in our society. And the legal system, as we'll be discussing, and the adversarial system fundamentally depend on tolerance for lawyers that represent unpopular and disfavored clients.
So is that norm against lawyer shaming, is that currently reflected in any ethical rules governing lawyers?
Yeah, absolutely. It's reflected in different ways, but the most on-point rule that we'll be discussing here today is ABA Model Rule 1.2b, which in my view rejects the fundamental premise behind lawyer shaming itself. And what it stands for is that representation does not equal endorsement. And so just to quote the rule, I promise I'm not going to be quoting and citing a lot of ethical rules today, but this one is important enough that I think it bears quoting in full. So to quote the relevant rule, a lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of the client's political, economic, social, or moral views or activities. And then the associated commentary to that model rule goes on to say that legal representation should not be denied to people whose cause is controversial or the subject of popular disapproval. By the same token, representing a client does not constitute approval of the client's views or activities. And every state, as far as I'm aware, has adopted some version of Model Rule 1.2b, and many states have also gone further and adopted some version of the commentary. And I think this rule and the commentary really illustrate how widely accepted the norm against lawyer shaming is in our legal profession.
Mm-hmm, that's helpful. So we've kind of set the context for this conversation. And so let's define our terms now. So when we use the term lawyer shaming, what is the definition of that?
Sure. So here's my working definition of lawyer shaming. It's basically criticizing, shunning, or punishing a lawyer using economic or social pressure simply for representing unpopular clients.
And when you say unpopular clients, do you really mean any unpopular clients? Does it matter what they've done or what they're involved with or why they're considered unpopular?
Yes. No matter what makes the client unpopular, no matter how despicable we as a society may regard the client, it's still lawyer shaming. And so, You can think of numerous examples of clients that are unpopular that might trigger lawyer shaming. So you could imagine, as we've discussed, sort of criminal defendants or suspected terrorists, large corporations that are in disfavored industries or are accused of misconduct, protesters and controversial speakers with offensive views, religious minorities, right? Whether they're, seeking accommodations for their faith or, perhaps seeking a better education for their children, say, or even abortion clinics and women seeking abortions, immigrants, seeking asylum, government bodies, and even political candidates. Sort of the list goes on, but from A to Z, sort of whatever makes a client unpopular, if a lawyer is shamed because they are unpopular, that's lawyer shaming.
Yeah, I think those examples that you just gave are interesting, and I think can really illustrate how lawyer shaming can easily reflect either explicit or implicit bias against unpopular clients, based perhaps on protected characteristics, so based on race or sex or religion or even other kind of, group identity status, socioeconomic status, family status, political ideology. And so I think that is helpful to recognize because, lawyer shaming really can have a disparate impact on marginalized groups, disadvantaged groups, which makes it harder for them to obtain equal access to justice. So now that we've kind of defined lawyer shaming a bit, how do we identify lawyer shaming and distinguish it from other forms of criticism? So there are a lot of ways people criticize lawyers or clients or their goals, and these kind of criticisms can kind of get mixed together. So how do we distinguish lawyer shaming, and how do we kind of pull that out and distinguish it from all the other noise?
Yeah, I think that's really important because these criticisms, right, as you say, often get thrown around together in our society. And I think it's really important for purposes of our discussion today and the unique ethical responsibilities of lawyers to sort of tease out the lawyer shaming aspect of some such criticisms from other criticisms that may present other problems in our society, but do not present the same sort of unique dangers of lawyer shaming, right? And so the key to remember from the definition is that lawyer shaming must be sort of criticism or shunning or attempted punishment directed at a lawyer simply for representing an unpopular client. So I think that it flows from that definition and those key attributes of lawyer shaming that a number of common ways of criticizing lawyers and their clients and representations are not necessarily lawyer shaming. So for one, criticizing violations by lawyers of legal ethics, right, is not lawyer shaming. So for example, criticizing a lawyer for filing vexatious pleadings or harassing, other parties and lawyers, or for misleading the court about the facts or the law, core like Rule 11, Federal Rule 11 type violations, that criticizing lawyers for committing those type of acts is not lawyer shaming and is quite the contrary, is actually appropriate and good for our society and our legal system. The courts sort of depend on these fundamental legal rules of legal ethics to do their job. And now that said, of course, we shouldn't throw around those sort of accusations lightly, right? And, they should be made in good faith. But putting that aside, sort of in general, these sorts of criticisms of litigation conduct, of representation conduct by lawyers that are unethical is not lawyer shaming. Second, attacking weak arguments themselves rather than attacking the lawyer is not lawyer shaming, right? So that's a key difference. That's what we do as lawyers, right? We engage arguments and we have to be able to say, this argument is incredibly weak or unpersuasive, right? And so as long as it doesn't turn into an ad hominem attack on the lawyer, it's not lawyer shaming. Keep the arguments, the attacks against the arguments themselves, not the lawyers, and then it won't be lawyer shaming. And then third, criticizing parties and their legal goals, of a representation is also not lawyer shaming, right? And so that it's entirely appropriate to say and argue, at least as a matter of the topic that we're discussing here today and the legal and ethical implications, that it doesn't matter whether a client may have the legal right to pursue a certain goal. Maybe that's immoral, right? And those sorts of criticisms, if they're directed at parties and objectives, is not lawyer shaming. It may present, like I said, other concerns. I'm not here to endorse cancel culture or anything like that. That's a big can of worms, conversation for another day, but it doesn't necessarily present the same concerns as lawyer shaming. And then lastly, it is not lawyer shaming to decline, for a lawyer to personally decline a representation based on strong moral objections to representing a particular client or pursuing a particular client's goals. Quite the contrary, when those moral objections are strongly held and a lawyer would regard a representation or a client's goal as repugnant, lawyers have an ethical duty under the rules to decline the representation if their moral feelings and objections are so strong that it would materially compromise their ability to zealously and objectively represent the client. So I think, again, just to reiterate, the key distinction here sort of is moral conscience, moral personal objections, right? Or is that why you're declining the representation, or are you declining the representation based on outside pressure, whether it be economic or social? That, the former is not lawyer shaming and is acceptable and, sometimes, actually ethically required under the rules, and the latter is succumbing to lawyer shaming.
Okay, that's a helpful explanation. So to make this a little bit more concrete, let's talk about some specific examples. There seems to have been a recent increase in lawyer shaming. And first, when did cracks in the broadly accepted norm against lawyer shaming really start to emerge? Can you comment a little bit about that?
Sure, absolutely. So in my view, the up until really 2011, our society and our profession were in a period of fairly strong commitment to the traditional norm against lawyer shaming. And I think that we can see that commitment at play in sort of the strong bipartisan backlash to some incidents in the late 2000s where conservatives actually attacked and attempted to shame lawyers representing the suspected terrorists detained at Guantanamo Bay, Cuba. And so there were two such incidents. The first was some comments made by a Defense Department lawyer named CLE Stimson in the Bush administration. And Mr. Stimson talked to the media, and he made some comments suggesting that corporations should actually encourage the private law firms representing the detainees to drop the detainees as clients, right? And what's so fascinating about this is the reaction to these comments were extremely swift, negative, and bipartisan, right? And so wide condemnation of these remarks as sort of fundamentally inconsistent with this core norm, right? And the Bush administration quickly walked back the comments, and CLE Stimson actually resigned his post within a few weeks, I think, of making these controversial remarks, right? And so the norm is holding pretty strong. And then again, I think a year or two later, Liz Cheney's group, I forget the exact name of it, but ran an attack ad against the Obama administration government lawyers who were appointed to defend the Guantanamo Bay detainees, and the ad sort of implied that the lawyers may have been sympathetic to the terrorists. And likewise, the reaction was strong, bipartisan condemnation of this ad as crossing the line and fundamentally inconsistent with this norm. And none other than CLE Stimson even came out, and condemned these remarks, learning from sort of invoking his prior experience, saying, this is below the belt, not an acceptable form of criticism of lawyers. And so the norm, again, in the late 2000s is holding pretty strong. But I think cracks really started to emerge in 2011 during a famous episode that I think most of the attendees here may be familiar with. And that's when Paul Clement, who was then a partner at King & Spalding, was actually attacked and shamed for representing the Republican-led House of Representatives at the time, which had stepped in to defend the constitutionality of the Defense of Marriage Act, more commonly known as DOMA, after the Obama administration refused to defend the constitutionality of that statute in court. And the shamers went after Paul and King & Spalding, and they even pressured King & Spalding's other clients in an attempt to get the firm to drop the House of Representatives as a client. And King & Spalding eventually did drop the House as a client, and as I think we all know, Paul Clement resigned rather than drop his client, which he felt was unethical and inconsistent with his professional duties. Paul Clement resigned from the firm to continue that representation. But still, even in 2011, what a lot of folks may not know, even if they are very well familiar with this incident, is that the reaction to the episode was still very negative across the political aisle and across the media. If I recall correctly, I believe Eric Holder came out and condemned the attempts to shame Paul Clement, And, a number of media outlets that and their editorial boards that we would all recognize as fairly liberal came out to condemn these attempts to shame Paul Clement and King and Spalding for their representation. So you had very strong editorials in the New York Times and the Washington Post and even Slate sort of, criticizing these attacks as inconsistent with this fundamental norm against lawyer shaming. And what's also so powerful about these op-eds at the time is that all of them are unified in condemning DOMA. They regard DOMA as bigoted and unconstitutional, and they call on the courts to strike it down. And so they obviously agree with the challengers to the law, but they nevertheless all took the position that the attacks on Paul Clement and the attempts to shame him and his firm were inconsistent with these fundamental American values.
Mm-hmm. So we have this kind of tenuous consensus in 2011, but that really seems to have broken down over the last decade or so. Can you think of some more recent examples of lawyer shaming in the last, handful of years?
Yeah, absolutely. And I think the norm has really started to crumble in recent years. That's, the increase in lawyer shaming has really accelerated over the last 3 to 4 years. And I'm happy to sort of give a brief overview of some of the more prominent incidents. So in 2019 and 2020, there were law student climate protests across the country at elite schools, law schools across the country that targeted firm recruiting events. And these protests specifically urged the firms to drop clients. I think there was a Drop Exxon campaign, and then there was a similar Drop Chevron campaign based on supposed climate change concerns. And these protests actually grew into the creation of a new student group called Law Students for Climate Accountability. And that student group now actually grades law firms, publishes an annual report grading law firms based on the amount of work they do for fossil fuel companies.
Okay, so however, I thought you just said that lawyers are allowed to have moral objections to representing certain clients. So isn't this law student example really preparing young lawyers and giving them more information to help them make better career choices that perhaps are more aligned with their moral values? So I guess I'm asking, is the law firm climate scorecard kind of a helpful moral tool in this context, or is it a tool of lawyer shaming? And how do you kind of flesh that out?
Yeah, that's a fair point. I mean, I think we generally regard information and disclosure sort of as good, right? And I think that's fair. And so this sort of information is not categorically a tool of lawyer shaming, right? It's not automatically lawyer shaming, right? But this sort of information and these sort of publications, they can be weaponized as a tool of lawyer shaming. And I think that's what was happening here, right? As part of these climate protests and what this student group is doing, right? That it is part of an overall campaign, right? With the explicit objective of getting firms to drop these clients, right? This is not purely about educating law students and lawyers, right, about their moral options when they make career choices, right? And I think we can see that in from two very clear aspects of this overall campaign, right? One is the protesters explicitly called for the firms to drop fossil fuel companies as clients, right? They weren't just directing their information, their protests at law students, right? And second of all, they are targeting the firm's non-fossil fuel clients, right? There's a concerted effort to persuade and pressure law firms' non-fossil fuel clients to get them to make pledges that they will not hire firms that represent fossil fuel companies, right? So in my view, the scorecard is part of an overall pressure campaign that is lawyer shaming, and so the scorecard is at least in part being used as a weapon of lawyer shaming. But there are several other, examples that we can discuss and briefly tick off. So just to give you a flavor of sort of how much the, lawyer shaming has increased in the last few years. So first, in 2021, Paul Weiss was viciously shamed on social media for representing the state of Oklahoma in a capital case, in a capital cert petition that was pending at the Supreme Court, before the Supreme Court, in which the state was defending its capital judgment. The petition presented some, issues, some tricky issues of Indian law that were presented after, the Supreme Court's McGirt decision, which I won't go into all that, the technicalities about Indian law. But the very arguments, actually, the court didn't grant this particular petition that Paul Weiss was shamed over, which happened to be a capital petition, but the very same arguments that the firm on behalf of Oklahoma was presenting in that case, eventually the court took up in another case, where Paul Weiss represented the state of Oklahoma, and Oklahoma prevailed on those exact arguments that were presented in this cert petition. But even putting the merits aside, right, it was really remarkable because, lawyers that should surely know better on social media lined up to shame Paul Weiss for taking on the state and defending this capital judgment. I remember one lawyer with plenty of followers on Twitter actually went so far as to even say that firms competing with Paul Weiss should use this representation of Oklahoma as a counter recruiting tool to basically distinguish their firms from Paul Weiss, marketing to, young lawyers, we don't try to kill people like Paul Weiss tries to kill people. And now I'm paraphrasing essentially what the tweet was, but that I thought was an egregious example of lawyer shaming and really crossed a line. In general, we've seen attempts to blacklist Trump administration alums simply for serving in the administration, sort of regardless of the legal positions that they took or the role that they had in the administration, just merely for serving. And similarly, in 2020, we had attempts to shame Trump election lawyers that were not even arguing election fraud. I want to table all that stuff, put all that aside. I think we all know, the usual suspects of the attorneys that pursued election fraud arguments. I'm not here to defend them whatsoever, and I think a lot of the criticisms against those lawyers are sort of the bucket that I was discussing earlier about criticizing lawyers for making ethical violations, right, like misleading the court about the facts and the law. Here, I'm talking about, even putting that aside, Trump election lawyers who made non-fraud arguments were viciously shamed, and I'm particularly talking about lawyers in Pennsylvania who pursued arguments based on the independent state legislature doctrine, which, again, I won't get into the wonky, like, what is that exactly, but suffice it to say, it's a fairly controversial constitutional theory, and it's hotly debated, right? But it is certainly within the realm of reasonable disagreement and ethical argument, right? And I think that's obvious from the fact that since Bush versus Gore, we've had several Supreme Court justices endorse some version of the independent state legislature doctrine, including current Supreme Court justices, right? And then the Supreme Court this very term took up a case to explore that doctrine, and whether it should be recognized and what it might look like, right? There's different versions of it, but in any event, it's impossible to say that these Trump election lawyers pursuing these sort of independent state legislature constitutional arguments were like outside the ethical bounds of reasonable lawyering. That's preposterous in my view. Again, you can disagree with the arguments, you can think they're totally wrong and off base, but they were well within the realm of reasonable legal argument, and yet these lawyers were viciously shamed and targeted. Insofar as the Lincoln Project, which is a group many of our attendees may be familiar with, but the Lincoln Project went so far as to dox some of these lawyers on social media, posting, and that term doxing just means publicly posting their contact information, their identities and their contact information on social media. And the Lincoln Project has thousands or perhaps even millions of followers on Twitter, and they published this contact information and explicitly encouraged their many, many followers to contact the lawyers and their firms and express their disapproval for their representation. Again, I want to reiterate, these are lawyers who are not pursuing election fraud arguments, right? And of course, what you'd expect from this is exactly what happened. A predictable stream of harassment directed at these lawyers followed, and it was too much even for Twitter. And and Twitter recognized this doxing post as a violation of its terms of service and its content moderation policies, and they took the post down, and they actually even temporarily locked the Lincoln Project's account and prevented them from posting because of this doxing post. And then fast forwarding a little bit to last year, just to make clear that lawyer shaming is not, a uniform problem coming from one side of the political spectrum. This is not purely coming from the left. I think we also saw some unfortunate lawyer shaming coming from the right in 2022, directed at then nominee, now Supreme Court Justice Ketanji Brown Jackson, was shamed during while she was under consideration for the Supreme Court for her prior service as a public defender. And in particular, 2 U.S. senators has some pretty unkind words for Justice Jackson about her prior service as a public defender. One Republican senator even went so far as to explicitly say that public defenders like Justice Jackson have their sympathies and their heart is with murderers and criminals, right? And I think that's textbook lawyer shaming in my view, and it should not have occurred. I think there are plenty of legitimate reasons, which we don't need to go into today, but there are plenty of legitimate reasons for folks to oppose, Ketanji Brown's nomination to the Supreme Court. Her service as a public defender should absolutely, in my view, not be one of those reasons, right? And then also last year, New York Times journalist David Einrich published a new book called Servants of the Damned, which basically, in my view, the whole book more or less is a giant lawyer shaming project. It's a criticism of big law firms and for representing particularly unfavored clients, mostly corporations and President Trump. And then just to bring it full circle, the last incident in 2022, bringing it, completely around again from 2011, Paul Clement and Aaron Murphy were forced to leave Kirkland & Ellis because the firm decided that they no longer wanted to represent gun rights clients pursuing their Second Amendment rights. And just like Paul Clement did in 2011, he and Aaron Murphy decided that they did not want to violate their ethical duties and drop their clients amid the representation, and so they decided to leave the firm instead, and now they have their own boutique firm. So lawyer shaming is an unfortunate circle, I think, from 2011 to 2022.
Those are all really interesting examples. I have a follow-up question about the Kirkland example, though. Is that really an example of lawyer shaming? On the other hand, I think most of us would agree that a law firm or partnership, has the right to set their firm values and, decide whether they have moral objections to representing gun rights clients, for example. So is that lawyer shaming? Is that not lawyer shaming? Can you kind of share a little bit more about that?
Yeah, of course. I think, again, another fair point. To be fair to Kirkland, we don't know for certain exactly what was going on behind the scenes with this incident and with their decision to stop representing gun rights clients and pursuing Second Amendment arguments, right? All we really have, more or less, is the Wall Street Journal editorial by Paul Clement and Aaron Murphy describing the incident and sort of describing the circumstances of their departure from the firm. And that, at least by their account, taking it at face value, it certainly seems to be that the firm dropped these gun rights clients because they are unpopular in certain circles, right? And again, that's Paul Clement's and Aaron Murphy's account. And I think based on that account, it sure seems like lawyer shaming to me. But I will admit, it's hard to tell for sure and make a firm judgment without greater transparency. Kirkland issued a short statement about their departure, but in that statement didn't make it clear that they were taking a moral stand or the partnership had conferred and determined that they had moral objections to representing these type of clients and these matters. And so it's really hard to tell for certain. But I think we should return to the point of transparency in these sorts of circumstances when we discuss solutions and strategies for addressing lawyer shaming.
Good point. So before we get to the solutions, can you help us understand a bit more, why is lawyer shaming so harmful? For example, why is it inconsistent with fundamental principles of our legal ethics? How does it exactly undermine the rule of law and equal access to justice?
Sure. So I think there are several reasons why lawyer shaming is so toxic and so harmful to our legal system and the rule of law. But at bottom, it's just fundamentally inconsistent with lawyers' limited role in our system, which is to further the rule of law by helping, society conform to the law, first of all, and navigate the adversarial system when there are disputes under the law. And so as a result of that inconsistency with that limited technical role of lawyers, a number of, harmful consequences follow. So for starters, it undermines the lawyer-client relationship, right? So by encouraging ethical violations. So lawyers that are under pressure, that are facing heat for representing unpopular clients, may be pressured to drop clients amid a representation, right? And the ethical rules are very clear that lawyers generally have a duty to see a representation all the way through to the end, and that if you do want to withdraw, you have to withdraw under circumstances that will not prejudice your client, right? And so lawyer shaming can pressure lawyers to abruptly drop their clients, to reduce the heat, and that can be a textbook ethical violation. The same sort of pressure can also encourage lawyers to break confidentiality, or to publicly criticize their client, right? A lawyer may, in an attempt to reduce the heat, may want to show that, do whatever they can to show that a client is not as perhaps unfavorable as they might seem, right? And so they might disclose confidential information to show why, the client's more sympathetic. That is okay with informed consent, right? So if you have informed consent, that sort of thing is fine, but a lawyer may feel pressure to do it without informed consent to reduce the heat. And likewise, a lawyer might feel pressure to publicly distance themselves from their clients, or to even criticize their clients to take the heat off themselves. And again, that is textbook ethical violations, right? But now pulling the lens back sort of a little bit beyond just the narrow lawyer-client relationship. Lawyer shaming just reduces the availability of effective counsel, right, for unpopular client. And that, of course, by definition, restricts access to justice, but it's going to, of course, harm minorities and disadvantaged clients. And the irony is actually that the general norm that we have against lawyer shaming is essential to maintain, precisely because there are some lawyers in our society that have strong moral objections to representing certain unpopular clients or clients with certain objectives, right? And so we need the norm to be maintained so that other lawyers that don't share those same moral qualms can step up and ensure that those clients receive access to justice. They can fill the gap, right? So reducing the availability of effective counsel, restricting access to justice, ultimately leads to worse legal outcomes, right? And courts in our adversarial system depend on zealous advocacy by all the sides in litigation to get the law right and the facts right. And so in the aggregate, lawyer shaming is going to lead to more legal and factual errors. I think that's just true, right? So it may be hard in any particular one case to say, the inability to hire this particular, better lawyer led to this incorrect outcome. That may be very hard to do on a case-by-case basis, to show the causation on a case-by-case basis. But I think in the aggregate, it's absolutely going to lead to more legal and factual errors. And it's also going to lead to worse compliance, right? So clients are going to receive, with reduced access to effective legal counsel, is going to be worse legal advice, right? And that's going to lead to worse compliance with the law. And it's also going to deter lawyers of integrity from representing, difficult clients, right? So when do you need a lawyer of integrity, right? You most need a lawyer of integrity for a client that you're worried may be difficult and may have a shaky commitment to the rule of law, right? And that's when we best, in the situation we most want, a strong lawyer of integrity to be there to say stop. And that is part of a lawyer's role, right? Is to draw lines sometimes and to advise clients that they cannot, no matter how much they want to, they can't take, whatever action because it would violate the law, right? But lawyer shaming just discourages those lawyers from being there and will ultimately lead to worse compliance, right? And finally, it erodes public confidence in the legal profession, right? So when all these things occur, you get reduced access to counsel, worse access to justice, more errors, right? And worse legal compliance. All of this is going to stack together and add up to reduced confidence by the public in the legal system. If the public has concerns that if I'm unpopular or disfavored, as the winds may shift for whatever reason, I'm going to have less access to the rule of law, less of an opportunity to benefit from the rule of law. And lawyers have an ethical duty to expand access to justice, to foster public confidence in the legal system and the legal profession, and to exercise civility and respect with regarding all participants in the legal system, including other lawyers. But Stephanie, I'm sure lawyer shaming can also have toxic, effects on workplace and law firm cultures. So I want to turn it back to you to discuss some of those consequences of lawyer shaming.
Yeah, those are really great examples, Jonathan. And to add to that, I think you're exactly right. Lawyer shaming does have an impact on law firm culture, right? Like workplace culture, and like any other shaming, right, in the workplace, that can create a toxic culture and ultimately weaken the legal practice. Creating a culture of fear and exclusion is the kind of the opposite environment we're trying to create with being inclusive, right, and respecting all employees and their viewpoints. And that type of environment can harm lawyer morale and increase law firm attrition, all of which can weaken the legal practice and stifle creative legal thinking too if lawyers are so afraid to do or say the wrong thing. So I think that's another example of the harmful consequences of lawyer shaming. So Jonathan, I am going to we talked about some negative consequences of lawyer shaming, but I'm going to play devil's advocate for a minute. How would you respond to someone saying that our American legal system and our adversarial system, are really tools of oppression, and kind of breaking away from the traditional norm that we've been talking about is actually a good thing, and that lawyer shaming can actually be a tool, to oppose, such oppression and injustice? How would you respond to that?
Sure. So I have three fundamental answers to this sort of lawyer shaming as a tool for fighting injustice sort of argument. So the first is it's fundamentally an anti-democratic end run around the normal political and adversarial channels that we have in our system for changing the content of the law and for adjudicating disputes under the law, right? And so, the impulse to fight oppression and to further, justice are totally legitimate impulses. It's just the way we channel those impulses in our system are to shaping the content of the law through the legislative and sometimes constitutional processes, right? And then when we have disputes about the content of the law, created using those processes, then we move to the adversarial system, right? And then that depends on sort of the zealous advocacy. For that to work, it depends on the zealous advocacy on both sides that we were discussing, right? So what this argument is really an attempt to do is do a complete end run around those channels and just push access to justice as a lever, as an anti-democratic lever for influencing the substantive content of the law. So in that way, I think it's illegitimate, but sort of even accepting the premise to the question that, our system, the legal system and the courts are, the adversarial system is a tool for oppression, which I don't share that premise, but let's accept it. I think once you discard the norm against lawyer shaming, there's just absolutely no guarantee that tool, wielding that weapon, is only going to be wielded by the folks that you like, right? That it's only going to be wielded for the ends that you like. And it could just as easily become a tool of the very oppressive majoritarian or elite forces that sort of are the premise behind, this counter argument, right? And so, there's no way to make sort of access to justice and lawyer shaming sort of immune from, at that point, once the norm is gone, immune from sort of the ordinary political and social forces that, you might otherwise regard as oppressive, right? And so once you discard the norm, it's just going to lead to a downward spiral in this way that you might say, okay, well, maybe we can partially discard the norm, right? Maybe we can say for these types of clients that we regard as particularly egregious, particularly bad, we won't retain the norm for them, but we'll still have this large area, of range of clients over here that will still retain the norm for. And I think that doesn't work because of this downward spiral problem. That line, whatever line, substantive line you come up with, is not defensible, right? It's not going to be, as a practical matter, it's just not going to be defensible, and there's going to be ever increasing calls to water down that line, reduce that line for, with questions of, well, if it's okay to shame lawyers for representing these clients, well, what about these clients? And many people are going to argue these clients are just as bad as those other clients. And how do we draw those distinctions? And so what you're going to end up doing, the downward spiral is just going to completely mirror, what you're going to end up with is a standard that just completely mirrors our political and moral priors, right? Our substantive views about justice. And again, now we're right back to lawyer shaming and access of justice just becomes a tool for, our normal, political, debates, right? And then finally, I do want to fight the premise a little bit of the question, which is that, the rule of law and effective counsel is an extremely powerful tool in our country for fighting injustice and advancing the position of disfavored groups and minorities, right? And look, I'm not naive. We have a long, long way to go in our country to to improve access to justice for all kinds of different groups, right, and clients, right? But let's not, we should focus on that and try to address that problem, but let's not also be blind to the great gains that we've made in our country using effective, zealous advocacy, right? And I mean, the civil rights era alone is a testament to the tremendous progress that can be achieved through effective lawyering for even very unpopular clients, right? And so it's really a remarkable thing in this country that, one single plaintiff challenging, suing to challenge a government, with nuclear weapons like the United States, or a large, powerful corporation with billions and billions of dollars, right? And if they're right and the law is on their side, and they can have an effective lawyer agree and convince a court, right, then, that lawyer can get the U.S. government or that huge corporation to comply with the rule of law, no matter how, weak or powerless that plaintiff might be. And that is a remarkable thing, and it's still achievable in our country, and I think it's only achievable in a system based on the rule of law with an adversarial system that is bolstered by the norm against lawyer shaming.
Mm-hmm. It's really good points. I'm going to ask you another tough question.
Sure. Excuse me.
Can't the market fix this? I mean, what's your response to those who argue that market forces can address these harms of lawyer shaming?
Sure. So, look, market forces are great. I'm a huge fan of the free market, as probably no one will be surprised to hear. But in this instance, I don't think market forces and competition are a complete answer to the challenges and harms and threats of lawyer shaming, right? It certainly can relieve some of the pressures of lawyer shaming, and I think that's visible in sort of the recent rise of conservative boutique firms, which have served as somewhat of a safety valve for some of these pressures, right? So like Paul Clement and Erin Murphy went on to start their own boutique firm, right, where they can continue to represent those clients that are unpopular in certain circles, right, despite the pressure that they faced, right? But not everyone is Paul Clement and Erin Murphy, right, to say the least, right? Not every lawyer can, has the resources or the ability to join or start their own, competitive boutique firm. That's for one. And of course, even accepting the market forces argument, right, it's undeniable that lawyer shaming is going to raise the cost and reduce the supply of effective legal counsel. And just under basic principles of economics, that's going to price out some unpopular clients from being able to hire effective legal counsel of their choice, right? And even if many other unpopular clients are still able to substitute other counsel, at the margin, there's going to be unpopular clients who are priced out of effective legal counsel. And look, to be sure, this is a general problem, right, with our profession, right? We are sort of in many ways a hybrid profession, right? We are certainly not a socialized profession, Lawyering is not a socialized industry, right? But we also, under the ethical rules, have public duties, right? Where, as we discussed, where we have public duties to further the rule of law, help society get as much access to justice as possible, right? And so the ethical rules sort of reflect and recognize sort of the discomfort between, the legal industry's ability and freedom to charge market rates, right? But also, that comes at the back end with a duty to further these values, these public values like access to justice through pro bono and other things, and to not, shame lawyers for representing unpopular clients, right? So at bottom, the problem with this market forces defense is not just that it doesn't completely answer the economic problem, but also that it's just fundamentally inconsistent sort of with the public role of us as a profession, of lawyers as professionals, right? That we're not just an ordinary business. We have this delicate public-private balance. And so I think the reflexive defense of lawyer shaming, to say, well, anything goes, lawyer shaming is fine, market forces will take care of this. I think that knee-jerk defense, reflects, I think, the erosion of the norm against lawyer shaming and the underlying, principles of the public role that lawyers play in our system. Mm-hmm. But I want to shift gears to solutions and strategies for avoiding lawyer shaming, and what the type of steps that lawyers and firms and other institutions like bars can do to address lawyer shaming, and how lawyers can avoid succumbing to it. So as we discussed before, I think a really important line between lawyer shaming and not is sort of this line between personal moral objections to representing certain types of clients and succumbing to outside pressure, right? So outside economic and social pressure for representing certain clients. So how do, Stephanie, help us here. So how do lawyers and their firms stay on the right side of that line and avoid lawyer shaming?
Yeah, it's a really, really good question, Jonathan. And I would say that clarity and communication are really key factors for solutions. So for law firms, for example, I would encourage them to set clear expectations with their internal attorneys that work for them and with their clients. Clearly define matters that they will not accept. Small boutique firms may have more easily identifiable values. However, big law firms, those firms' values can be more difficult to infer without increased transparency, in this context. So I think transparency is critical. About a law firm's transparency about their values avoids, kind of the appearance of condoning shaming, right? I think law firms can also, in this context, cultivate a firm culture of respect, civility, and respect for and encouragement of public service. And for example, they can do that by adopting policies, explicitly favoring, viewpoint diversity in their hiring and in their pro bono, matters and practices. Also, consider being explicit about prohibiting the blacklisting of lawyers from disfavored administrations, for example, or similar forms of public service. So essentially just being explicit and upfront and transparent, adopting policies that incorporate, the values that we've been talking about today.
No, that's great. Those are great recommendations, Stephanie, and I think really useful. So what role does education play in all this? What can or should, organized state bars or bar associations, even law schools do to address lawyer shaming and get out ahead of it?
Mm-hmm. Yeah, I think education is another just crucial part of this conversation and solutions to combat lawyer shaming. So law schools, for example, could address lawyer shaming in their professional responsibility courses. For example, state bars, bar associations, law firms can offer CLE programs like the course that we're doing today about the harmful consequences of lawyer shaming, and instead, really cultivate a culture, of viewpoint diversity. State bars also, when there is, high-profile event of lawyer shaming, in the news or whatnot, could use that opportunity to condemn it and use it as an educational opportunity within their communities. I also think that individual lawyers or law firms could educate their clients about this topic, as we've been talking about, sometimes facing external pressure from clients, right, in this context. So utilizing those situations to inform and educate clients about, our profession's ethical duties, the unique role that lawyers play in our legal system, and the consequences of lawyer shaming that we've been talking about today. And as you just mentioned too, law firms are businesses, but they're not ordinary businesses, right? So lawyers have a public duty to maximize access to justice, especially, for the unpopular and disadvantaged that may otherwise struggle to obtain, high quality legal representation. So I recognize that these proposed solutions will not necessarily be easy to implement, and sometimes, might involve swimming upstream in our culture today. So it might take a little extra courage and a little extra fortitude, but lawyers should be known for that anyway, right? So moving a bit to attorney discipline, changing the topic just a bit. What about attorney discipline, addressing lawyer shaming by the state bars? Is that an option on the table to combat lawyer shaming and the implicit bias behind it?
Yeah, that's a tough one, Stephanie. So I think the short answer is, at least as the ethical rules currently stand, I think attorney bar discipline to address lawyer shaming is not really an option the way the rules are currently worded. The principles that we were talking about, things like, ABA Model Rule 1.2b, those relevant principles are really stated as broad sort of aspirational values that all lawyers should, aspire to fulfill and to further, but they're not really phrased in terms of concrete, prohibitions that can trigger attorney discipline. Now, that said, discipline can perhaps address some of the effects, the symptoms of lawyer shaming that we discussed, right? So if a lawyer, abruptly drops a client, amid a representation, to avoid the heat of lawyer shaming, right, in a way that prejudices the client, or if the lawyer breaks confidences or criticizes their client in a way that would clearly violate the ethical rules, those actions in response to lawyer shaming can certainly be addressed through discipline. But that's treating really the symptoms of not the disease itself, which is lawyer shaming, right? And so the tricky part is that in addition to, the current rules not really being worded in a way that invites attorney discipline, the First Amendment is also, an independent constitutional barrier, at least to some degree, right? So much lawyer shaming is going to be protected speech, right? So if you go on social media, even if you're a lawyer and you shame another lawyer for representing an unpopular client, and you're not involved, you're not sort of like adverse to that lawyer in a particular matter, right? Then that's probably protected speech, even for a lawyer. I mean, it is true, lawyers have somewhat limited speech rights. Their speech can be, because of their unique public role in our system and their role as officers of the court and, as administrators of justice, right? They do have, somewhat more limited speech rights than, your average, your regular non-lawyer citizen would be. Certain restrictions of lawyer speech pass constitutional muster that would not pass muster if they were directed at a private citizen. So perhaps in some narrow circumstances, lawyer shaming speech can be sanctioned. For example, I don't know, maybe I haven't really analyzed this very deeply, but perhaps, if a lawyer is, directly shaming his or her adversary, right, in court, maybe at that point, if it's particularly egregious, a court can use its, supervisory contempt power, something like that, to punish or discipline the lawyer shaming there. But the First Amendment, a broad-based attempt to discipline all lawyer shaming is going to face very serious, in my view, First Amendment obstacles, even taking into account the somewhat reduced First Amendment rights that lawyers have, right? But that said, I mean, maybe a narrower rule, right? And I don't know, it would very much depend on the particulars of the rule, but perhaps a narrower rule addressing, certain agreements, perhaps to not represent certain types of clients. I don't know exactly. Again, I don't want to go too far into the hypothetical, but maybe certain, a rule addressing agreements like that. Maybe those agreements are analogous to sort of secondary boycott type agreements, which borrowing some sort of from the labor law context where secondary boycotts are not protected speech and can be prohibited in the labor context. Maybe there's a constitutional analogy there to give an opening for a narrowly targeted ethical rule. I still think it would raise very difficult constitutional questions, though.
Mm-hmm. Okay. What about the new ABA Model Rule 8.4G? Can you educate people on what that is, and could that rule be used to combat some of the implicit bias behind lawyer shaming?
Yeah. So my view is that quite the contrary. I think Rule 8.4G. Proposed by the ABA, may actually worsen and encourage lawyer shaming. And just to remind the participants, Model Rule 8.4G prohibits, quote, conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of 11 protected characteristics in conduct related to the practice of law, right? And so the protected characteristics are race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status, right? And the rule, by its own terms, it purports to not limit, what clients, lawyers can represent and what arguments they can make, but it may actually limit the advocacy that lawyers can do for clients outside court. And where that possibility comes from is the extremely broad and problematic definition of, quote, conduct related to the practice of law. And so the commentary clarifies that phrase, conduct related to the practice of law, includes, quote, participating in bar association, business, or social activities in connection with the practice of law. So speeches, debates, remarks, presentations at conferences, seminars, and even, Federalist Society events like, programs like this, right, could get swept up in the prohibitions of 8.4G. And for starters, that raises significant First Amendment concerns. Just last March, a federal judge, a Trump appointee in Pennsylvania federal court, actually held that Pennsylvania's version of Model Rule 8.4G actually violates the First Amendment because it restricts protected lawyer speech that actually does not interfere with the administration of justice, right? And so the name of that case is Greenberg versus Goodrich. I won't give you the citation, but just you have the name of the case if you want to go a little deeper into the constitutional concerns around 8.4G. But those free speech concerns aside, punishing out-of-court advocacy by lawyers for clients, in my view, is textbook lawyer shaming. And the rule itself can also, beyond just directly restricting that advocacy out of court, which for many clients is just part of the bucket of representation, right? We often think about legal representation as being limited to courts or transactions or something like that, but representation of a client can often include far more than just those sort of discrete situations, right? It can include out-of-court advocacy. But even, beyond just those sort of direct restrictions on lawyering that 8.4G may impose on lawyers, the rule may discourage lawyers from representing unpopular or controversial clients out of, fear that a lawyer might cross the line in one of these other areas, right? These out-of-court areas, or just the mere fact that the representation of the unpopular or controversial client may invite increased scrutiny under 8.4G, either by the bar authorities enforcing the law, the rule, or by other lawyers, or others reporting violations of the rule. In our profession, we have the tattle rule, right, where lawyers are supposed to report ethical violations by fellow lawyers. And so a lawyer might just avoid representing a controversial or unpopular client out of fear that, their fellow lawyers that may not share their views or may have, stronger objections to representation of these particular clients may be sort of waiting in the wings to pounce, to report them for supposed ethical violations under 8.4G, right? And so in this way, the rule may actually amplify the implicit and explicit biases behind lawyer shaming, the biases, that are reflected of those enforcing the rule and those who would report violations, right? And so this can end up just furthering majoritarian views over minority unpopular views. And so in my view, 8.4G is certainly not the answer to lawyer shaming, and state bars should instead focus their attention on educational efforts to inform lawyers about the dangers, of lawyer shaming that we've discussed here today. Mm-hmm. But with that, that ends the prepared portion of our programming here. I want to thank Stephanie again for the wonderful conversation. I think we covered a lot of really interesting and important ground, and I want to thank the Federalist Society again and the Freedom of Thought Project specifically for hosting this great program. And with that, I want to open it up to Q&A. I'm going to turn it over here to my page for the chat so I can see, oh man, we have lots of questions already in the chat here. We're at just over an hour in our program, so let's try to get some questions in here today. So first question, is there an argument or risk that law firms that force out lawyers who represent politically unpopular clients or force lawyers to drop politically unpopular clients are violating the ethical rule you discussed at the start of your presentation? And yeah, I think the short answer is yes. I think as we discussed with the Kirkland example, I don't want to pick on Kirkland. We don't know for sure about that situation, but yes, if there are situations where firms are forcing out lawyers. Oh, I see the question here. It's forcing out lawyers may violate the ethical rule. I see the focus of that question. So, yeah, I think it can be, if the point is that a lawyer wants to represent a client that's particularly disfavored, right? That if it's motivated by, an objection to a particular, social and economic pressure because this client is unpopular, right? Then I think it could be lawyer shaming. But again, if a firm wants to take a clear moral stand and say, this is, the views of the partnership, we have moral objections to this particular type of matter or client, representing this particular type of client, then they're allowed to do so under the ethical rules. And I think if they are clear about that that's what's going on, then they can avoid the perception either by the lawyer or either by the lawyers at the firm or by others that they're engaged in lawyer shaming. I hope that answers that question. So could there be any consequences for lawyers who file frivolous and partisan bar complaints as part of lawyer shaming? Without commenting on, I think I know what this question is referring to, and I think without weighing in on the specifics of any particular bar complaints, I think in theory, yeah, I think as I was suggesting when we discussed the ethical violations and criticisms of ethical violations as not lawyer shaming, we shouldn't take that too far and wield those sort of accusations lightly. And the bar complaints are part of this, right? When you make accusations of ethical violations, I think they can be wielded as an unethical tool, just as, any other legal tool could be wielded in an unethical way to harass or, and ethical violations, accusations of ethical violations can be just as frivolous, right? And so the short answer is yes, accusations of ethical violations and bar complaints can bleed into lawyer shaming if they're made in bad faith and used just as a tool of lawyer shaming and don't actually reflect, a good faith debate. There's going to be margin cases, right? With ethical rules, right? There's going to be, tough calls, but if they're made in bad faith and not close calls, then that can absolutely be lawyer shaming. So, all right, here's one I think for you, Stephanie. So the movie Philadelphia involved, that's an interesting start, right? The movie Philadelphia involved a claim of wrongful discharge of a lawyer from a law firm. I'm curious about the state of employment law for lawyers in law firms and the question of viewpoint discrimination. Would a law firm that discharged an attorney for espousing unpopular beliefs or representing unpopular clients be subject to any ethical sanctions? And I think within that question is sort of, could it be violating the law?
Right. So I can talk about that from an employment standpoint. So law firms are employers like any other company, right? So are subject to discrimination laws. So I think it depends on the, I guess I'll give you the typical lawyer answer. It depends on the facts of the situation. Yeah. But potentially, yes. I mean, if they are, applying policies inconsistently, and that's based on, the departing lawyer's religious views, for example, or something like that. So the potential is there, absolutely.
Okay, great. So let's see here. Clarification question. If the ethics rules say an attorney must refuse a client he finds repugnant, doesn't it follow that lawyers who don't refuse a client must not find the client repugnant? So I think the answer is yes, although, look, there's a space under the rules for, you can absolutely represent a client that you find morally objectionable, you disagree with their aims, right? You don't share their political or moral views or goals, right? That is okay, right? And in fact, to some degree, I mean, I think that's certainly true with like criminal defendants, right? I think it's safe to assume that criminal defense attorneys in our country don't have sympathy, or condone sort of the crimes that their clients are at least accused of committing, right? I think but that said, the ethical rules actually do encourage us, to take on clients that are unpopular and disfavored, even if they make us a little bit uncomfortable, I think. And so the bar, I think, for declining to represent a client, based on these sort of moral concerns, I think is deliberately pretty high, and it has to be, your moral objections to the representation have to be so strong, you have to regard the client or their goals or beliefs as so repugnant that they would materially compromise your ability to zealously represent the client. So I hope that provides the clarification. What about law firms who force lawyers and clients that pressure firms to push out lawyers who served in a controversial administration as at the conclusion of the Trump administration? Are those firms acting ethically? I mean, I think that's a tough call. I think, again, if you're blacklisting a lawyer simply because of the administration they served in, which is, a client, right? The Trump administration, in my view, is just as much a client as any other client, right? They're a unique type of client, right? But they're just as much a client as any other client. And I realize that government lawyers have somewhat different ethical responsibilities because they serve in this public role. They're not just, to some degree, their client is the people in our country, right? It's not just one particular administration or one particular person in an administration. I get all that, right? So that may affect the ethical question of whether they violated their ethical duties, right? But putting that aside, let's assume they've made good faith arguments and they've not violated their ethical duties that are unique to government lawyers, right? They're being blacklisted, simply for serving in an administration. I think that does cross a line and into lawyer shaming and is at least, again, inconsistent with the fundamental ethical principles underlying the rules. Again, it may not subject a firm or lawyers to attorney discipline, but it's inconsistent with those core values under the ethical rules. Does this analysis change if core societal values are at stake? Is it fine to defend a Nazi if they're a tiny minority, but what if the potential client promotes ideas that might appear to be, quote, catching on? I think the analysis doesn't change, right? I think that's just, again, we have a long history in our country of a long and celebrated history in our country of lawyers representing deeply, deeply unpopular clients, and sort of whether a threat is rising, so to speak, is, again, that might be relevant to your sort of moral calculus of whether you have strongly held moral objections such that it would, make it impossible for you to ethically represent the client. But in terms of the outside shaming, I don't think, it's appropriate to say it changes the analysis to say, well, these views are particularly odious and they seem to be, gaining momentum. So it's our view to push on lawyer shaming as a tool to fight back against that new trend. I don't think that changes the analysis. Should we think differently about judging lawyers for representing unpopular clients than lawyers representing unpopular litigation positions? For example, the House of Representatives versus Guantanamo terrorists. What do we make of the Guantanamo terrorists being regarded as perhaps less controversial than the House? Yeah, well, if the Guantanamo terrorists are less controversial than the House, that's a broader societal problem that, I'm not going to get into. But, I don't think, again, if the criticisms are ad hom attacks directed at the lawyer for representing the unpopular client or for taking ethical litigation positions on behalf of the client, I think they're equally lawyer shaming, right? Again, if you're criticizing the argument, the litigation position, whatever the relief you're trying to seek, whatever it may be, as weak or inconsistent with the law, right, lacking legal support, that's all fine. It's just when you attack the lawyer directly for representing the client or for taking a particular legal position. Again, it crosses a line, though, if your view in good faith is that the lawyer's litigating position is so weak, so frivolous that it's unethical. That's okay. And then the criticism can be directed against the lawyer themselves. I've seen articles asking whether it's time for us to abandon the idea that lawyers shouldn't be judged for their clients and embrace accountability culture. Other pieces ask if it's time for journalists to rethink, quote, objectivity. Is this part of a larger phenomenon? What's going on here? Okay, good question. So this is something we originally thought about including in the programming and decided, not to address today. But it's interesting that it's interesting that it was brought up today in the Q&A. Sorry, I'm watching another question come in. Sorry about that. It's complicated, I think. I don't want to speculate too much, but I think this is absolutely part of the same forces that I think are driving cancel culture to some degree, and that itself is a super complicated phenomenon with, a lot of different causes that are hard to address in our society and hard to explain, and I'm sure a lot smarter people than I have thought about what's driving the rise of cancel culture, but it does seem to be part of a broader rise in intolerance in our country and the attempts to shrink the Overton window of the scope of reasonable disagreement in our society, right? And just generally raising the stakes of these disputes with our neighbors and our fellow citizens, right? That, we used to be able to, I think, disagree agreeably a lot more. And I think there's an overall deterioration of that in our society, and I think, frankly, it's sadly bleeding into the legal profession. And so, in some view, at least in my view, lawyer shaming, the rise in lawyer shaming, is a manifestation, I think, of this broader problem of cancel culture and the rise of general intolerance for civil disagreement, in our country. What about lawyer shaming in the context of pro bono work in big law? Should clients be pressuring firms to not engage on the, quote, wrong side of controversial questions? What can be done about that practice? Again, I do think, again, if it's exerting social or economic pressure because a particular type of client or unpopular group is unpopular or disfavored, I think it is lawyer shaming. Again, it's a tough line, though, because, again, clients can have values, right? And firms can have values. And, again, if this is part of a values discussion and the firm wants to have that transparency, right, and take a stand and say, this is how we view the role of our pro bono work, and this is how we feel that pro bono should further our values, then I think it's not necessarily lawyer shaming. Again, but transparency is absolutely essential here, because without the transparency, you can't really know what's going on behind the scenes here. You don't know if the firm is responding to economic and social pressure, or if they're just adopting certain values, which they're allowed to do, right? And so I think that's part of the same conversation. And so what can be done about it? Transparency, right? I think, you put it really well, Stephanie. I think transparency can help, address that problem and help avoid lawyer shaming and pro bono. Sorry, I've been monopolizing the answers to these questions because I see them. But do you agree with that about how to handle these challenges with pro bono?
Yeah, no, absolutely. No, I think you're spot on with all your answers, Jonathan. So, no, I think that's great, and I think just talking about why lawyer shaming is harmful and just communicating these ideas to broader audiences is helpful, just to help with the civil discourse that you were mentioning before, and kind of pushing back on these movements. I think just explaining the harmful consequences of lawyer shaming and sort of things in that realm, and making sure that we're communicating our ideals and values in a positive way, so people are familiar with them and can start to kind of embrace the underlying values of our legal system.
Sure. So a couple more questions and then we'll wrap up, because I know we're almost 20 minutes past 2 o'clock. So how do we distinguish opinion about the strength of arguments from lawyer shaming? Are unpopular arguments also more likely to be regarded as frivolous by the legal elite in crowd? So I think this question is a good one, and I think it touches a little bit on topics we've discussed, but the second half I think is really insightful. So like I said, there's always going to be hard cases, right, about legal arguments, and it's not self-evident, what is a frivolous argument, what argument is so weak that it crosses a line from reasonable legal argument into, unethical frivolousness, right? There's always going to be debates about that, what falls on what side of the line, and I think, those debates are good and appropriate. They're healthy for our legal system, as long as accusations of unethical conduct are not thrown around lightly, and wielded as backdoor tools, for lawyer shaming, right? The second part of the question, are unpopular arguments more likely to be regarded as frivolous? I think that's unfortunately true. And I think some of that might be going on with like the independent state legislature, discussion that we were having before about why these lawyers, in these Trump election lawyers in Pennsylvania who were not making fraud arguments were so viciously shamed and attacked for making these legal arguments, right? Is that there's a lot at stake, right? The outcome of the election, or at least we thought, maybe some thought at the time. It turned out, Pennsylvania, I don't think would have mattered to the outcome. Or even the particular legal dispute there, I don't even think would have affected the outcome in Pennsylvania. But putting all that aside, I think because the stakes were really high, right, and people felt that these were sort of anti-democratic efforts by candidate Trump, President Trump, right, to nullify an election, right, I think, and so people feel really passionately and strongly about that, right, I think it does bleed into and affect, how people view the strength of the legal arguments. Not all, but I think some, and I think even some academics, I think, have been, drawn into this, temptation to regard these arguments as completely frivolous and baseless and off the wall, beyond the pale, right? And look, again, I'm not an expert on the independent state legislature doctrine. I know there are very elite, brilliant academics and historians on both sides of the independent state legislature question, and there's all kinds of a spectrum of views in the middle about what, even if there is an independent state legislature doctrine, what it looks like, right? There's plenty of room for heated disagreement among lawyers and scholars on that, but I think it's still, these arguments are well within the bounds of ethical, reasonable disagreement, and I think we shouldn't let the political passions, right, that so often whirl around litigation shouldn't affect our sort of clear-eyed, objective view of what's a frivolous argument and what's a reasonable one. Mm-hmm. And then finally, one last question. You seem to be among the few ringing this bell, I guess sounding this alarm, and it seems it should be a bigger deal across the profession. Is there a statement we should be presenting to schools and law firms for sign-on? Well, I'll tell you right now, I'm not aware of one at the moment. It doesn't currently exist, but there were ones back in, involved in the, surrounding the Guantanamo Bay detainee incidents. Actually, there was actually an open letter circulated and signed by something like 130, law school deans in this country, vigorously condemning the attempts by conservatives at the time that we discussed to shame the public and private lawyers representing the Gitmo detainees. And it's a really powerful letter. If you Google it, you can find it. And something like that, we might need in our current moment. So with that, I'll close the Q&A period. I want to, again, really thank you, Stephanie, for taking the time to do this. It's been a really wonderful conversation, and thank the Federalist Society and the Freedom of Thought Project for hosting this program.
Thank you, Jonathan, and thank you to the Federalist Society for hosting this much-needed conversation. Thank you.
On behalf of the Federalist Society, I want to thank John and Stephanie for the benefit of their time and expertise today, and thank you all to our audience for joining and participating in this event. We welcome listener feedback by email at info@fedsoc.org. For anyone who has registered for CLE credit, you'll receive an email with a link to the certificate of attendance. If you don't receive the email within 3 business days, please contact us at cle@fedsoc.org. Thank you all for joining us today. We are adjourned.